Good morning to you all, and welcome to the latest webinar in the series of webinars from Mason Hayes and Curran's education team. A particular welcome to any of you who have not joined us before and are here for the first time. My name is Ian O'Hurley and I'm head of the education unit in Mason Hayes and Curran, and I'd like to introduce my colleagues on this morning's webinar, Liam Reardon, Catherine Kelly and David Ruddy. Many of you will be already familiar with one or other of us, so hopefully it's nice to see us again. So today's webinar is on child protection procedures for secondary schools, and we're asking the question, I suppose, are they effective? And overall, we think that they are really effective. Schools are very much a safer place for students than they were in the past. But nonetheless, there are some particular, if like bumps in the road, which we're going to try to identify today. So just a word about what we're going to do on today's webinar and what we're not going to do. What we're going to do is I suppose, share with you a number of the issues that are coming across our desk and maybe share with you some of the lessons that your schools have learned and what we've learned as well in supporting your schools. What we're not going to do is try to present to you in sort of 30 or 40 minutes a comprehensive guidance on the child protection procedures for secondary schools, because I mean, without stating the obvious, there's a substantial piece of legislation, Children First Act. There's Children First, the procedures that preceded the Act, and there are child protection procedures, guidelines, procedures from the DES, which run to about 100 pages. So you can imagine that, you know, there's no real prospect of us being able to go through the entire procedures in 30 or 40 minutes. Just a couple of housekeeping things. You know, we have the Q&A and the chat functions turned off because there are, thankfully, from our point of view, a very large number of you, several hundred on this webinar, and it wouldn't really be effective to, or possible for us to kind of take questions as we go along from such a large number. So let's get kicked off, and we're going to look at kind of two broad themes today. One is child protection issues from outside of school. Obviously, in that scenario, the kind of theme of our presentation is that since the concern, the allegation, the issue is outside the school, you're going to be working very closely with TUSLA because you don't know about the issue other than what you're told really by TUSLA. And then the other issue we're going to be looking at is child protection complaints, allegations, concerns relating to a member of staff. And that's just to say that is a really tricky situation. We're going to be coming back to that as we go along through this in the second part, I suppose, of our webinar. So you'll see, you know, the kind of headings that we're going to be looking at there, and we'll be running through those as we go along. So just on the second issue, just to go back to the second issue there, the procedures. The second issue is, as I said, a very tricky issue. And there are two particular chapters. If you're unfortunate enough to have to deal with a child protection complaint, allegation, concern, suspicion, whatever, against a member of staff, there are two particular sections in the procedures. There's chapter 7, which actually tells you in a very good way how you need to process an allegation or suspicion of child abuse against an employee. And there's chapter 9, which is a new concept, if you like, in child protection procedures. It's what is referred to as the oversight section. And this is really a sort of an oversight section for boards of management. Prior to this, it was much more a section or a process for the DLP and principal of the school. This is a new section. We're going to be drilling down into some of those issues as we go through this. David.
Thank you, Ian. Good morning, everyone. And we're asking you this morning to participate in an anonymous poll, an online poll, in relation to how child protection has impacted on you. And in particular, have you ever had to make a mandated report in relation to a child protection concern for a child? Has there ever been an allegation against a member of staff that you have had to deal with as a board? And finally, I suppose 4 years into these procedures, do you feel they're working for your school? So when you get a chance there, you might participate in the poll, and I'm going to ask then Ian for his reaction.
Yeah, well, and just while people are voting there, just to give you a second, I mean, just in particular, looking at number 2 there, this is something that we talk about a lot on our team. The situation where you're having to deal with a complaint and allegation suspicion against a member of staff is, we believe, the most tricky issue that comes across our desk, because it's where your obligation, your duty of care, your child protection obligations to students or to a particular student comes, if you like, into contact with your obligations to your staff and to a particular staff member, and your obligations to be fair and your obligations to be supportive to a member of staff. So this is, and we're going to be returning to this in a couple of minutes, but this is a really, really tricky situation, and one which really required very careful consideration.
Thanks, Ian, and thank you to Catherine Madden of our events team who has organised this poll. So you can see there 68% having made a mandated report to TUSLA, and then 14% in relation to a member of staff. And finally, very positive 91% feel that the procedures are working for them. Does that surprise you, Ian? Or
No, I'm kind of comforted to see that there's 91% who think that the procedures actually work, and that would be our view as well. I mean, we think, and I said this at the outset, we think schools are so much safer in the wider sense for students than they might have been in decades gone by. So that would be, it's interesting that 14% has had to deal with a complaint against a member of staff, because that's where the rubber hits the road, as it were, in terms of these procedures. That's where things get very tricky. So hopefully we'll be able to say something helpful to everybody today.
Okay, thanks for that, Ian, and we'll come back to you in a few moments. I'm going to move on to Liam. Good morning to you, Liam. How are you?
Good morning, David. I'm very well, thank you.
Liam, just at the outset, can I say that, would you agree that the Children First Act and these procedures really have been a game changer for schools, in the sense that all teachers now, registered teachers, are mandated persons, and that there's more burden sharing, whereas in the past the GLP had the responsibility to carry it all, as it were, on his or her back?
Yes, I think that's a fair assessment, David. The 2015 Act, as you say, it spreads the load. It puts a statutory obligation on all teachers registered with the Teaching Council, on all professional teachers, to report any reasonable concerns of harm above a threshold to TUSLA, and to assist TUSLA in its investigations and in dealing with those concerns. And so it's not just the DLP who has the obligation to report, it's every practicing teacher, every teacher registered with the council. Now, what does this mean in reality? I mean, the reality in our experience is that in most cases where a teacher has a concern, she or he will report that concern to the GLP, and the teacher jointly with the GLP will make a referral to TUSLA. And if that's the case, if the DLP and the teacher are jointly making a referral, that fulfills the teacher's statutory obligation under the Children First Act. It's foreseeable that a situation could arise where a teacher brings a concern to the attention of the principal principal makes an inquiry of TUSLA as to whether a referral should be made. TUSLA says it doesn't meet the threshold of harm. The principal decides that no referral has to be made. The teacher disagrees with that. And what should the principal do in that situation? And what we advise is, well, you tell the teacher what you've been told by TUSLA and why it is that you're not making a referral. And it's up to the teacher then, as the mandated person, if they feel that they need to make the referral as well. But I think the key thing to bear in mind on it is that the statutory obligation is to report concerns above a threshold. And that threshold is determined by TUSLA. It's what they call the threshold of harm. And they are the ones who decide on that. And just going back for a second, David, if I could, just going back to the previous slide, just to make a point in relation to the different kinds of abuse. There is
sorry, yeah, okay.
Yeah, no problem. There are definitions of physical abuse and sexual abuse and neglect in the Children's First Act. There is no definition of emotional abuse. Emotional abuse is treated as ill treatment. And ill treatment in the Children's First Act is defined as cruelty and abandonment. So TUSLA has a bit of a problem with emotional abuse because of the absence of a definition of that in the Act. And I know Catherine has been dealing with quite a big case on emotional abuse. She'll be talking about that later on in the webinar.
Thanks for that, Liam. And speaking of Catherine, we're going to move on to the next slide here, and in relation to reporting of concerns.
I think there's maybe the previous slide, David.
Oh, sorry, I have an issue with my slide sorter here. So
no problem.
Yeah.
Thank you.
It's gone a bit crazy today. Yeah.
It's Friday.
Yeah. Okay. I think this is your piece here, Catherine.
Yeah, in relation to the definition of harm, and I know Liam was discussing that on the previous few slides. It's assault, ill treatment or neglect of the child in a manner that seriously affects or is likely to seriously affect the child's health, development or welfare. And I have had a few recent cases in relation to assault, ill treatment or neglect. Assault is pretty clear cut in that I've had a recent one where an allegation was made that a teacher dragged a student across the classroom. He was on the floor and the allegation was that the teacher dragged him across and was rough with him. This was reported to the principal by an SNA in the classroom, and the principal quite rightly rang TUSLA and got advice from TUSLA, and TUSLA stated that it had to be reported. So she did report it and it was investigated. There was another assault allegation which was made, this time in relation to a parent. A student in a post-primary school came in after a weekend with a parent and had stated that his parent had assaulted him. And it was quite serious and he was quite upset. So the class teacher, as referred to earlier, went to the principal and made the report, and a report was made to TUSLA in that instance as well, and it was investigated. Ill treatment, can be quite subjective. We have had numerous occasions of emotional abuse. I'm going to deal with one later, which is in relation to a teacher who had so many allegations of emotional abuse. I mean, it was children that were not sleeping at night, physically affected by what was allegedly going on in the classroom. And that was a difficult one to deal with because, again, TUSLA, because there's no definition of it, it's more difficult to get TUSLA to take it seriously. And in relation to neglect, I had a case where it just shows how the procedures can work so well for schools, because they picked up on a student who they felt was suffering from neglect in the home, unfortunate situation, separated parent, suffering from alcoholism, and the school stepped in I made a referral to TUSLA, and that ended up in a very positive outcome, which just shows how, you know, it can work very favorably for the student involved. Sexual abuse of a child is more clear-cut, and we deal with those kind of historical abuse allegations, but there is no threshold in relation to that.
So,
I
Catherine,
think it's worth saying, David, that just to comment, because we were talking about this before the webinar. I mean, TUSLA really struggle around complaints of emotional abuse, and I think it's just, I know Catherine is coming back to that. They really kind of struggle around emotional abuse and sort of the definition of harm and the threshold, but it's something that we'll come back to.
Yeah, and we have discussed it before in that, you know, for example, if you had 12 parents coming to the school saying there was, you know, a physical assault had taken place, well, then it would be very clear cut, and, you know, TUSLA would deal with it. But when you've got 12 parents coming and talking about emotional abuse, then it's not as clear cut, and it can take a lot longer to deal with.
Yeah.
Catherine, is your default position to seek advice from TUSLA? Would that be your advice?
Definitely. Yes, absolutely.
Okay, that's good. The next piece here, we're just going to look at the duty of care of a teacher. And I know in particular you have talked and you have dealt with anonymous complaints that have been sent into schools, and that how do you treat an anonymous complaint?
Yeah, it's very difficult, and we get asked this all the time. We get principals phoning us to say that they've received an anonymous complaint in relation to a member of staff, and our advice would always be to seek advice from TUSLA. TUSLA will not be able to do anything usually because it's anonymous, and obviously the staff member would be entitled to know who's making the complaint and what's being said about them. So it's not going to be something that will be investigated by TUSLA, but you should keep a note of having rung TUSLA and sought their advice in relation to it.
And Catherine, Liam talked earlier about the statutory functions of a mandated person, a teacher. What happens when a teacher doesn't discharge those statutory functions?
Well, there are no criminal sanctions on teachers, but there are a number of possible administrative sanctions, like a complaint to the Teaching Council, report to the National Vetting Bureau. And the one that we come across most frequently is the teacher could be the subject of disciplinary procedures.
Right, thanks for that. And I'll come back to you in a few moments. We're next going to move on to the role of the board. So we've talked about the DLP and we've talked about the mandated person. Ian.
Thanks, David. And I suppose we're going to talk about maybe specifically about complaints against a member or concerns about a member of staff. And I'm going to look at a couple of slides coming up just in relation to that. And obviously, a lot of principals are listening in today who are DLPs, because 90-something% of DLPs in schools are principals, although it doesn't have to be the principal. But the Board of Management has a role in child protection as well, and we're going to be looking at that particularly in a minute. But I mean, firstly, it has a role in the sense that it's the employer, the hirer and the firer of staff. So that has a particular issue, and particularly, as Catherine just said, for example, in the area of physical abuse, we have dealt with numerous situations where a teacher has been the subject of a complaint of physical abuse. Those complaints wouldn't always necessarily be dealt with at, for example, stage 4. It may be that, you know, a teacher crossed a boundary, but not necessarily in a gross way, and it might be dealt with at one of the earlier stages in the procedures. But the Board of Management, as your slide says there, has an overarching oversight with child protection and employment, obviously as the hirer and firer, but also with child protection. And if we go on to the next slide, you will see, well,
tell us about the next slide.
Little slide that David has thrown in there, the elephant in the room. I think it's a rather cute picture, albeit that it's a bit weird. But the elephant in the room, I suppose, is meant to indicate that, you know, this area of complaints against staff member is a really, really tricky tricky situation. And it's a giant, it can be a giant issue, as I've indicated previously. And if we go on to the next slide, you'll see that we've put up there a kind of a summary of what the particularly Chapter 9 of the Department's Child Protection Procedures says in relation to what a child protection oversight report by a principal to a board of management has to include. And you principals will all be familiar with this because you have monthly board meetings or more than monthly board meetings. You'll be familiar with the obligations to make a child protection oversight report to your board. So if you look down, particularly the first column, the blue column, you will see the matters that a principal is required to report to the board. And I'm not going to read them out here, but you'll be all familiar with those from Chapter 9 of the procedures. But I do want to look at B in particular. And B says that your principal's child protection oversight report to your board must include details in relation to any advice sought from TUSLA and on their advice as furnished where it was not reported to an incident or a concern or an allegation was not reported to TUSLA on TUSLA's advice. Now, this, and we only had a situation like this a couple of weeks ago on the team. This is potentially a situation where a concern has arisen in relation to a member of staff, but following an initial assessment, both the principal / DLP and TUSLA, where the principal has sought advice from TUSLA, all these people have no concerns. But the oversight requirement requires that that teacher's name must be put out to 8 members of a board of management, not anonymized. Now, many of you will be familiar that, there's a provision in the procedures for the anonymization of children's names. But we really have a bit of a problem here because, for as long as we've all been dealing with child protection issues, one of the principles around sharing of information is that information is shared on a need-to-know basis because for obvious reasons, confidentiality and whatever. And we really struggle with why a board of management must know the name of a staff member where an issue has arisen, where the principal has no concerns, no child protection concerns, and where TUSLA has no child protection concerns. And we've given advice, for example, to the management bodies and to anybody else who listen to us, that we think that this particular requirement is fraught with difficulties and will potentially lead to legal difficulties down the road. So I just want to highlight that to you. It is a requirement on principals. If you don't comply with it, you're not complying with the procedures, but it's going to give rise, we believe, to serious difficulties. Now, these child protection procedures, I just finish up by saying, are due for review, regular review, and we're hoping that this issue may be looked at on a review because we...
Can I stop you there for a second, Ian?
Yeah.
It just occurs to me, say you're a principal and you have to make that, you have to report that to the board management. I'm just conscious that, say, for example, in the case of, I would say, Catholic secondary schools, the articles of management require you to notify a teacher if there's going to be some report or referral to the board which is adverse to them. Should a principal tell the teacher in advance of reporting the teacher's name to the board of management? In terms of fairness.
Yeah, no, well, that's a very good point. And I'll answer that in a second, but just to say that provision that it's only in the articles of management for secondary schools, but it does reflect a general obligation to notify somebody if they're going to be criticised, and give them an opportunity to respond. So in short answer, Liam, I think that there is an obligation to comply with the Articles of Management of Secondary Schools. But even in the wider sector, if a teacher's name is going to be furnished in accordance with B there to all members of the Board of Management in the context of what I've just discussed, we do believe that the teacher has a right under fair procedures and natural justice to be advised that this is going to happen, which may give rise to issues with the teacher and the union or whatever, but that's what the procedures say. So, you know, we're just putting it out there. Thanks, Liam.
So thanks, Ian and Liam, and it's very much the elephant in the room, as alluded to in the slide there. The next piece here, we're going to talk about the question of the Department of Education's inspections of schools in relation to child protection. Now, in fairness to the department, they did not apply for this particular role, but TUSLA and the Ombudsperson for Children were insistent that there would be some inspection model, and it's at 3 different levels. The very basic one would be 3 compulsory checks, which would include checking to see that the child safeguarding statement and the accompanying risk assessment is posted publicly, that it has been signed off by the Board of Management, etc. Level 2 would be part of a whole school evaluation process and would have 8 compulsory checks. And then we have level 3 monitoring, which is relatively new, and it's quite forensic, and it takes place over 2 school days. There are 10 checks and up to 65 sub-checks. And these, this particular inspection is published. So schools are very conscious of their reputation, and particularly in relation to child protection. Just in relation to the reports themselves, as of yesterday, when I checked up on the department website, there have been 68 of the level 3 inspections, and you can view them there. In fact, it's a very worthwhile exercise. And you'll see there are 2 visits, an initial one and a final one. And the final one is which is reported. The department give about 48 hours notice. And there also is an online parental survey. So ultimately, there are different levels of compliance. At the lower level, not compliant, partially, substantially, and obviously we all would like to be fully compliant. In fairness of the reports I looked at on the second visit, they would have been fully compliant. The department obviously would have given notice when there was a partially compliant or substantially compliant issue. And by and large, it's partially and substantially rather than not being compliant. If you'd like more details on that, you can reference Circular 72/2020, or indeed there's a link there to a PDF version of the inspections. And of course, best of all, just go online and have a look at some of the schools that were inspected. Okay,
David,
I want to move on.
Sorry, David.
Oh, sorry, Liam, I beg your pardon. Sorry. Yes.
I just on that compliance point, you know, just go back to Ian's thing. Could a school find itself on the back foot with regards to compliance if they didn't report the name of a teacher to the Board of Management? You know, just on Ian's point, if they, absolutely. Is that something which could be held against you on a GES inspection?
Absolutely, Liam, and you know, it's a very good point. They certainly will go through the Board of Management minutes, and they have access to the files, the secure files, etc. And it would be a big, as the procedures stand at the moment, it would be a big black mark, in my view, against a school.
So that could show up on your on a WIP, for example, a WIP report.
Oh yes.
Sorry, a whole school evaluation. Sorry, not a WIP. A whole school evaluation report that was published online, for example.
Yeah, absolutely. And these child inspection reports are published online too, so it would very much show up in these. So until the procedures are reviewed and what Ian has highlighted, taken on board, and by the way, when these procedures were being discussed at departmental level with the partners, board management and unions and staff associations had huge reservations about them. So yeah, absolutely. Thank you, Liam. Catherine, I'm going to come back to you in relation to an allegation against a member of staff. And you're of the view that there are certainly two aspects to this. So would you like to discuss this with us, please?
Yeah, there are two separate procedures. So it's the one in the procedure, the child protection procedures which involve TUSLA. You're obliged to report it to TUSLA and they may investigate it. But there is also another procedure then, which are the employment procedures, the disciplinary procedures, because the staff members is an employee of the Board of Management. So if there's any allegation, in relation to any kind of misconduct, then that may need to be investigated by the Board of Management down the line. Normally what we say is that TUSLA investigate first, and the board will wait and see what the outcome of those investigations are, and then you reserve your right to investigate under the disciplinary procedures if the board feels that it should.
Thanks for that, Catherine. And we're going to move on to the next piece about the protocols. So an allegation arrives on the desk of the principal or DLP. What do they do when they receive the allegation?
The most important thing is to go to the procedures in relation to the protocol authorizing immediate action, because they're quite technical and it's very, very important that you comply with those procedures. Just this week, we were advising a school that had an issue that came up, and they didn't fully comply with the protocol authorizing immediate action, and then you're kind of on the back foot, you're trying to backpedal. As it turned out, it was fine. We dealt with it, and TUSLA stated that there was no issue, and all they stated in relation to that was that the principal needed to have a word with the teacher when he was back from his leave. He was only out for a day or two. So this allows the principal to take a moment to investigate it, to see what TUSLA are saying in relation to it. And then Liam is going to deal with it in the next slide, I think. It may be necessary then to put that teacher out on administrative leave while the issue is being investigated. But the protocol authorizing immediate action is very much an immediate thing for a day or two. You ask them to absent themselves. It's not a disciplinary issue, and should be made very clear to the employee that it's not disciplinary. It's merely precautionary. Okay, they're told about the allegation and they absent themselves.
So, Catherine, is the protocol all about giving people, the staff member and the principal, space?
Absolutely.
Right.
Absolutely. Just to take a moment, to investigate it initially, to see what the issue is, and then maybe to take further steps if necessary.
Thanks for that, Catherine, and we'll come back to you shortly. Liam, once the protocol has been implemented and that we have then to move on, as it were, can you take us through the steps, please?
Yeah, absolutely, David. And if you find yourself in this position as a principal, you really do need to take legal advice, and that's not us advertising our wares or touting for business. You really do need to make a phone call to someone like us, and because this is where it gets real, as it were. You have to notify TUSLA. You've got to contact the department and make arrangements for a substitute teacher, and most importantly, there has to be an emergency meeting of the Board of Management to consider placing the employee on administrative leave, because even though the emergency protocol is there, as Catherine was saying, to provide some space, only the Board of Management as the employee can actually, or as the employer, can actually place the teacher on administrative leave. And the teacher needs to be given notice of that, needs to be advised of rights to representation, and needs to have the opportunity to make a case to the board as to why he or she shouldn't be placed on administrative leave. And if you don't get that right, if you don't give the teacher that opportunity, you can hit the rocks legally, as it were, and your procedures could be tainted, could be irredeemably tainted. So it's important that you get these steps right.
Liam, can I come back to that point about legal advice? In the past, when TUSLA gave advice as to whether a staff member should be put on admin leave or not, there was a lot of resistance, particularly from trade unions, saying that a social worker should not advise in relation to employment issues. So the role of TUSLA, the advice there is in relation to the child protection, whereas you as a lawyer, advice is in relation to employment.
Yeah. You're absolutely right. It's a decision for the Board of Management only. And if you ask TUSLA for advice, they won't give it. It used to, the thinking used to be was that when somebody was placed on administrative leave, that was the end of that, so to speak. You could not quite forget them, but they were sort of out there, and you didn't really have to worry about that aspect of things. What changed that thinking is a case that we're going to be discussing shortly, which is Riley and the Bank of Ireland, where Riley was an employee of the Bank of Ireland who was left on suspension for a very long period of time while the bank conducted an investigation. He was years on suspension. And the High Court found that was fundamentally unfair. He wasn't given an opportunity to make any representations to the bank as to why he shouldn't be on suspension. And the reason why we emphasize the importance of the employee having the opportunity to make representations to the board is firstly because of Riley and the Bank of Ireland. And then secondly, the child protection procedures themselves put a lot of emphasis on the importance of due process and fairness in the board's dealings with the teacher under investigation. So it's important that this is not just treated as a sort of, a rubber stamping type exercise or a box ticking exercise whereby a teacher is simply put on admin leave. You refer the matter to TUSLA and that's the end of it. It's not that simple.
Liam, I think just to say, I think you and I dealt with a case in the last number of weeks where you went back to TUSLA seeking advice in relation to a risk issue, and it probably might be helpful to share that one.
That's right. Yeah, I did. This was a case where a principal was informed by TUSLA that he was the subject of a retrospective complaint going back a long time. They didn't tell him what the nature of the complaint was. And they didn't tell the management body what the nature of the complaint was. They said to the principal that he should more or less, he put himself on administrative leave. And he was very concerned about this because he's had an unblemished record of whatever, 10 or 15 years as a principal. He's held in very high regard in school by his colleagues, students, management body, and so on. And so, so we were concerned about this, and we looked at the procedures, and we said to TUSLA, well, why can't you tell us what the nature of the allegations are? And they said, we're not going to deal with you because you're a third party. And we had a look at the procedures, and the procedures say that in circumstances where TUSLA has a real concern about the safety of the child or children, they can tell a third party, such as a board of management, they can tell the third party the nature of the allegations before they tell the person against whom the allegations have been made. But in circumstances where they don't consider that there is an immediate risk to the health and safety of children, they don't tell the third party. They only deal with the person against whom the allegations have been made. So we said to TUSLA, well, given that you're not telling us what the complaints are, you clearly don't consider that there is a fundamental risk to health and safety. So why are you somehow insisting that the principal goes on admin leave? And they accepted that completely. They rode back from their original position 100%. We put in place, certain protocols which were quite easy with the principal for fairly obvious reasons, and he was happy with that. TUSLA were happy with it, and that's sort of it. Yeah.
Thanks, Liam, and that highlights what Catherine said was, the fork in the road between the child protection issue and the employment issue, two different strands, as it were. And there's a very good article, if I may say, by one of our colleagues, in relation to this particular case. I think you'll find it useful. I now want to move on to, as it were, the final piece in this webinar, and it's the pulling together of different bits and pieces and experiences which have been learned, as it were, through handling quite a number of cases. So Catherine, I'm going to hand over to yourself, and maybe Ian and Lean, feel free also to come in.
Yeah, we've had a number of cases which have led to disciplinary procedures following a TUSLA or a Garda investigation. And you'll see that first bullet point is due process, and it's always very important to remember that the person involved, the member of staff involved, is entitled to fair procedures and natural justice. So if you are going down the disciplinary route with this staff member, they are entitled to know what's being said about them and entitled to have an opportunity to respond to any allegations. What happens sometimes is that TUSLA or the Gardaí are investigating, and you agree with the trade union representative for that employee that you're not going to do anything in relation to any disciplinary procedures while that investigation is ongoing. Now, this presents problems sometimes, because I've had cases where you could be waiting to hear from TUSLA for a year and a half, 2 years, and the member of staff is out on administrative leave for 2 years. It's quite a long period of time to be waiting. My advice in relation to that is that you should keep in close contact with TUSLA, ask them how it's going. Just keep a note of the fact that you're not just sitting back and allowing that staff member to stay out on administrative leave long term. So when TUSLA come back, there may be a finding against that employee, which is quite straightforward then. You go down the disciplinary route, and then you have to decide which stage of the disciplinary procedures you go under. If they don't make a finding, sometimes the employee comes back and says, well, there's no finding, so I'm coming back to work. But that's not the case. You can go down the disciplinary procedures with that employee. We would normally say, you're out pending the TUSLA investigation and any other investigations that may be carried out by the board in this regard. So that covers you. So those are the things that you need to think about, to suspend the disciplinary process while everything else is ongoing, and that may take some time, unfortunately, but we would always advise that you wait.
And just to pick up on what Catherine said, we've had a couple of cases, and I've ended up a couple of years ago in court, sort of defending the board of management and its handling of a situation where there was an ongoing TUSLA investigation. And as Catherine said, like, the TUSLA investigations can take a very long time. And sometimes they take long because the teacher and the teachers' union threaten legal action against TUSLA. We've had that. And TUSLA can get into a kind of a semi-paralyzed state where they're not really making judgment calls and decisions. And this can result in the administrative leave of the teacher continuing for a very long time. And I have been in court where a judge, raised eyebrows about the length of time that the teacher was on administrative leave. Now, we were able to say that was because TUSLA's investigation was ongoing. But there is a kind of a general principle in employment law that if you're suspending or putting a member of staff on administrative leave, it will be only for the minimum period necessary. And if you get into a situation where a TUSLA investigation is going on, and Catherine and I, Liam, have had this for 3 months, 6 months, 12 months, in one case, 18 months, it's very hard to defend. But the one thing that I would just pick up on and reiterate that Catherine has said is the board needs to be keeping in regular and constant contact with TUSLA, preferably keep a paper trail, so that if it's called upon later to justify what it did or didn't do, it's able to say, we were on to TUSLA, we were on to TUSLA, we were on to TUSLA. It's a huge protection for boards of management.
And I did have a case where we agreed with the trade union representative. There was a Garda investigation in relation to one matter, and that we would not proceed. And, then, we get a letter when everything has finished, talking about how we have delayed on the issue. And it was great to be able to go back to the letters which confirmed that they were the ones who asked for it to be suspended pending the outcome of the investigation, and to say, no, there's been no delay on our part. It was agreed between the parties. The other thing I would say is to keep in contact with the department, because the department also want to know what's happening with this teacher and his or her administrative leave. So you need to keep in close contact with them also.
Catherine, on that point, what happens if TUSLA come back and say that there is evidence of misconduct, or in fact, if they come back and say there isn't, what is the role of the board in relation to that?
Well, then it comes down to what the allegation is and how serious it is, and you have to go and look at the disciplinary procedures. And is it, stage 1 or is it stage 4? It very much depends. And obviously, the disciplinary procedures allow you to skip stages depending on the seriousness of the allegation. In the one I was talking about earlier, which is the teacher allegedly dragging the child across the classroom, there were no findings made in relation to that, but the board decided that they would go down the stage 2 route. So they wanted, to bring it to bring the teacher through a disciplinary process. They were given a written warning, which was appealed to the board, and the board felt that the written warning was fair. So that it did not uphold the appeal there. In relation to the emotional abuse, which was the 12 allegations in a classroom of emotional abuse, that was, unfortunate, because again, TUSLA didn't really make a decision on it. The teacher was out, it took a long time, it was 18 months, and then no findings made against that teacher. But the board decided that it was so serious. I mean, these children were not sleeping, 12 sets of parents coming forward is very, very serious. And they decided that they would instigate a stage 4, which ultimately led to the dismissal of that teacher. And she appealed that to the disciplinary appeal panel. And we were told at the time that she had been given full fair procedures, natural justice. The procedures had all been followed perfectly, but that they felt that the sanction was too tough on the teacher, and they decided to give they changed it to a final written warning. And my concern in relation to that is that the teacher involved, because, I was involved with that school, the teacher involved had never expressed any remorse, never accepted that her behavior could have that effect on the children. And therefore, my stance on it is, how can you give a final written warning to somebody? Because that states that there's an improvement. But if somebody doesn't accept that what they're doing is wrong, it's not suitable for a final written warning. But, that's my opinion on it, and that's what happened in that case.
I think one of the big messages, David, is as Catherine said, is like, yes, the TUSLA decision may inform a board as to what course of action it takes, but once this board decides on a course of action, it can't simply rely on TUSLA's decision. It has to run its own procedure, and it has to, if you like, from a disciplinary point of view, present the case to answer itself and not just TUSLA's decision. That's important.
Yeah, and in that case, it would have been a very detailed stage 4 report by the principal to the chairperson, going down through every single thing that had happened, all the allegations involved. It would have gone on for pages and pages, extremely detailed, because obviously that teacher is entitled to know every single thing that has been said and be allowed to respond to it. So it's very, very important that you get that right.
Thanks for that, Catherine. And I'm going to go back to Ian there for unfortunately, time has caught up with us. And Ian, I'm going to give you on Focal Geranuk. So over to you.
Come on, good. Okay, well, I mean, the takeaways, any of you who have been on previous webinars will be bored to tears listening to the first one, and that is to read and familiarize yourself with the child protection procedures if you have an issue. And if any encouragement, and I've said this before, we get the procedures out every single time, when there's a problem, because think you remember them from the last time or whatever, but just take them out. They're very detailed, but they're actually helpful. Obviously, you always need to take advice from TUSLA. There's a provision, as Catherine has said earlier, for an informal call to TUSLA, without actually going into names and things, as to whether TUSLA advised there should be a mandated report. Very helpful to principals, utilised very regularly by principals, and they find it helpful. Obviously, if as I said, if the rubber hits the road and you're dealing with a complaint against a member of staff, tricky. You need to be very careful, take advice. Take advice from your management body, take advice from legal advice, whatever, but take advice. Obviously, overriding concerns, keeping children safe, staff entitled to due process, and review your safeguarding statement annually. It's in the procedures, and you should do that. Other than that, it just falls to me to say, firstly, thank you for tuning in today. I hope you found it helpful. As I said at the outset, we weren't intending to literally start. This wasn't the procedures 101 guidance. This was just picking out some of the issues that come across our desk. One thing I would say to you, if you get time to do it, we find it really helpful, is to complete the online survey that will pop up on your screen if you registered for this immediately after this. So if you want to complete it immediately afterwards, or you want to complete it later. But the feedback that we get from registrants on our webinars is really helpful to us. You get to rate us. So if you think we're good, fine. If you think we're useless, that's fine too. But you also get to comment on, the topic, future topics and whatever. And it's really helpful to us to keep us on our toes, firstly, but also to guide us about how we can support you going forward. You'll also get a recording of this webinar if you feel you want to look at it again, or to maybe to share it with a colleague. Other than that, from us all, thank you again for listening, and good luck.
Thank you.